Hello, and welcome to Organized, the Business Law Breakdown. I'm Professor Seth C. Oranburg, and today we'll begin our exploration of general partnerships, and we'll start with their formation. But we don't just study general partnerships because we want to understand general partnerships. We're actually going to learn really fundamental lessons about how business organizations work in general, because partnerships are a foundational organizational type. The simplicity and accessibility of general partnerships makes them a common business structure. And they also are older than corporations. And even modern organizations still have many partnership elements in them. So we need to understand partnerships first in order to understand the other structures we're going to be covering. And importantly, partnerships come with unique legal risks and legal challenges. In this lecture, we'll discuss what constitutes a partnership, how one is formed, and why these basic concepts matter in both legal and practical terms. So what's a partnership? At its core, a general partnership is a business association between two or more people who agree to carry on a business as co-owners for profit. This is the definition found in the Uniform Partnership Act, Section 202, if you're counting, of 1914. And it's still the dominant definition in basically every U.S. jurisdiction. And it has a couple key elements. So simply parsing this one definition can teach us a lot about what partnerships are and why they are. So let's take a look at it step by step. A business association between two or more people. Partnerships require at least two participants. People actually means more than you might think. It isn't just natural persons like human beings, but in a legal sense, persons can include entities like corporations or limited liability companies. Next, the business has to engage in a profit-making intention. They are carrying on for profit. And this makes these type of associations different from nonprofits or other organizations. You might get together with 15 people in your apartment complex to play a softball game. That's an association of more than one person, but you're not carrying on for profit. Or 10 people might agree to meet every Friday in order to pray. But that, again, isn't designed as a business for profit. So those aren't going to form general partnerships. Partnerships, as a rule, have to be for profit. Third, co-ownership is essential. The individuals involved must not only share the profits, but also the control of the business. And that also means they're going to share some of the risks, as we'll see in a moment. This shared control, this equal sharing, distinguishes partnerships from other relationships, such as employer-employee or lender-borrower, or for that matter, corporations, where there's a deliberate separation of ownership and control. Shareholders don't run the day-to-day operations of a corporation, but partners have the rights to do that. So how are partnerships formed? One of the most important characteristics of general partnerships is they don't require any formal legal filings to come into existence. And this makes them different, once again, from corporations or LLCs or a variety of other forms which have to file specific documents to exist. To create a corporation, you have to file the articles of incorporation, or to form an LLC, you have to file the articles of formation. But a general partnership can simply arise from the actions or agreements of the parties involved. And this means they can be formed by accident. Again, under Uniform Partnership Act, Section 202, the definition we read earlier, a general partnership is a business association between two or more people who agree as a business to carry on as co-owners for profit. And that has no intention requirement. At least there doesn't have to be an intention to form a business or a partnership. You just have to have the intention of carrying on for profit. If the elements of a partnership, co-ownership, profit sharing, business purpose, if those are present, the law recognizes the relationship as a partnership. And that means both the benefits and the costs accrue. Sharing profits is a key indicator of a partnership. So under the law, an agreement to share profits generally creates a presumption that a partnership exists. Now, there are exceptions to the rule, because there are all kinds of profit-sharing arrangements that we know aren't partnerships. So an agreement to pay wages with some kind of bonus for sales commissions, or receiving loan repayments on a periodic schedule provided that an apartment is rented, those don't necessarily establish a partnership because they aren't carrying on as co-owners. Additionally, while a written partnership agreement is advisable, it's also notable that partnerships can be formed without any writing. It's not necessary for an agreement to exist for a partnership to exist. Again, they can happen accidentally. So a partnership can arise based on oral agreements or even on conduct alone. For instance, if two or more individuals simply act as co-owners of a business and share the profits, they may have inadvertently formed a partnership whether they want to or not. And this concept, which you could call a partnership by accident, highlights the importance of understanding the legal framework governing partnerships, because some people end up in situations where they have liabilities they didn't expect. Let's try to make this a little less abstract with some examples and illustrations of partnership formation. So we'll consider a few scenarios to clarify how and whether partnerships will form. Let's imagine a couple different people. Instead of A, B, C, D, and E, I'll name them. Let's start with Alice and Bob. Alice and Bob decide to start a landscaping business. They agree to split profits equally. They agree to share decision-making powers, and they agree that they will jointly own the equipment. And this is a clear example of a partnership formed with intention. But again, intention is not required. So if these elements are present, even without intent, we might still have a partnership. So let's talk about Carol and Dan. Carol and Dan co-own a rental property. Dan has all the responsibilities for tenant relations, and Carol, she only handles the finances. They split the incomes from the rent, but only Dan puts forward money for any kind of advertising expenses. Even so, they have an unintentionally formed partnership because their conduct aligns with the statutory definition. And that's true even if they didn't know it or intend to create a partnership. Now let's take an example of Evan and Fiona. Let's say Evan lends money to Fiona's bakery, and in exchange, Fiona is going to pay Evan back a certain percentage of that money for the next 12 months. This arrangement almost certainly does not create a partnership because Evan's acting as a lender, not as a co-owner of the business. There's no assumption that he has any control, and in fact, our general understanding of debt would mean that he doesn't. So that's probably not going to create that relationship, but we could tweak it a little bit. And what if instead of lending money to Fiona in exchange for a percentage of the debt paid over time, what if Evan got a percentage of profits? Well, now we have something closer to a partnership, although it could simply be a security, an investment contract, which is one thing that is not a partnership because it's reliant on Fiona's efforts, not Evan's. But now we're a little bit closer to seeing how a fact-specific inquiry is required to determine if a partnership is formed. Again, we have to look at whether the elements of the definition in Uniform Partnership Act Section 202 are met. So why does this matter? The rest of this season is going to talk about why partnerships matter because they have legal implications. But in brief, partners in a general partnership have unlimited liability for the partnership's debts and torts, which means each partner is personally liable for the debts and other obligations of the business, including any harms that it causes to any other people. If a partnership can't pay its debts, creditors can pursue the personal assets of any partner, and not just the one who issued the debt or agreed to take it on, because partners have joint and several liability for the partnership's debts and torts. Additionally, partnerships impose what we call fiduciary duties on the partners. We'll talk about fiduciary duties in a lot more detail in a future season because they're worthy of their own specific topic. But to give you the gist, partners owe each other a duty of loyalty and a duty of care. The duty of loyalty means they have to act in the best interest of the partnership. And that means they can't take opportunities for themselves that rightfully belong to the partnership. And the duty of care means they have to avoid negligent or reckless behavior, and they're responsible if they do. Another critical aspect of partnerships is what we call joint and several liability, and it was mentioned above. The legal concept of joint and several liability means any partner can be held fully liable for the wrongful acts committed by other partners if they're done within the scope of the partnership's business. So the ease of forming partnerships also creates a variety of risks, because partnerships can be created without formal filings or actual agreements. Disputes over management, profit sharing, and liabilities often arise. And so for this reason, it's highly advisable to have a lawyer draft a written partnership agreement that clearly outlines each partner's roles, responsibilities, and expectations. Such agreements can help mitigate conflicts and provide clarity in the case of disputes. As we close, consider this. Why does the law allow partnerships to form so easily? In fact, why does it require the formation of partnerships even without formal filings and even without an intent to form one? Who is the law protecting in these cases? What are the benefits and risks of this approach? And how might you advise a client who wants to collaborate on a project? Have you learned anything today that helps you understand how collaboration on a project can create liabilities you wouldn't have expected? We'll learn more about these as we continue in the season. But for now, thank you for joining me on Organized, the Business Law Breakdown. I'm Professor Seth C. Oranburg, and in our next lecture, we'll delve into the default rules that govern partnerships, including management, profit sharing, and decision making. But until then, thank you for listening and take care.